Welcome once again to Customs GST Advisory channel of the customsgst.com. We request you to subscribe our channel. Your subscription will encourage us in deep diving into the new engrossing topic in the customs and GST regime. Let us begin today with one more trending and important topics. What if I told you that in a GST show cause notice, the word suppression does not create suppression? What if writing the words fraud, willful misstatement, and suppression of facts is not enough to unlock the extended limitation period under Section 74 of the CGST Act, 2017? And what if the Supreme Court has now made it clear that the department must do something much more difficult? It must put before the taxpayer the foundational facts from which fraud, willful misstatement, or suppression can actually be inferred. That is the real significance of the Supreme Court's latest judgment in Tata Steel Limited versus Union of India, decided on 25 August 2026. The proposition emerging from the judgment can be stated in one sentence. Suppression is a jurisdictional fact, not a drafting formula, and this is not a completely new philosophy. It is the continuation of a jurisprudential thread running from Cosmic Dye-Chemical through Pushpam Pharmaceuticals, Anand Nishikawa, and other Supreme Court decisions on extended limitation. Tata Steel has brought that principle into the GST era. At the very outset, let us first understand Tata Steel decision by Honorable Supreme Court. The dispute concerned show cause proceedings for 3 financial years, 2018-19, 2019-20, and 2020-21. The proceedings originated from an audit objection concerning mismatch of input tax credit and alleged short payment of tax. The department invoked Section 74 of the CGST Act. And that immediately created the central legal problem, because Section 74 is not simply Section 73 with a longer clock. Section 74 is the exceptional provision dealing with cases involving fraud, willful misstatement, or suppression of facts. The assessee's case was therefore straightforward. If there is no legally sustainable allegation of fraud, willful misstatement, or suppression, how can the department access the extended limitation period? The department, on the other hand, relied upon the alleged suppression and also referred to the former explanation 2 to Section 74. The Supreme Court had to examine not merely whether tax may have been short paid. It had to examine whether the department had established the statutory gateway to Section 74 itself. Here is the first conceptual mistake that GST Department often makes. A tax authority may establish that there is wrong ITC or short payment of tax or excess refund. But that does not automatically establish fraud, willful misstatement, or suppression. These are not interchangeable concepts. Think of it as a legal equation. Tax short payment is not same as suppression. ITC mismatch is not same as suppression. Incorrect declaration does not automatically means willful suppression. And therefore, Section 74 cannot be reached merely because Section 73 would produce an inconvenient limitation date. The exceptional period is available only when the statutory conditions for the exceptional period are satisfied. That distinction is fundamental to the judgment. Now we reach the most important passage in the Tata Steel judgment. The Supreme Court says that for proceedings under Section 74, the proper officer must be satisfied not merely that a mismatch or short payment has occurred. The officer must be satisfied that fraud, willful misrepresentation, or suppression led to that mismatch or short payment. That word, led, is crucial. The court is demanding a causal connection and not casual connection, not merely tax was short paid, not merely ITC was wrongly availed, not merely information was not declared, but what was deliberately concealed, by whom, why, and how did that deliberate concealment cause the tax consequence? That is the deeper logic of Tata Steel decision by Honorable Supreme Court. This brings us to the central proposition of this video. Let us carefully understand it. Suppression in Section 74 in itself is not a word, it is a factual conclusion. And a factual conclusion requires facts. The Supreme Court therefore rejected the idea that an SCN can simply reproduce the statutory vocabulary and thereby create jurisdiction under Section 74. The court expressly said that the foundational facts leading to the inference of fraud, willful misrepresentation, or suppression must be evident from the notice itself. And then comes the sentence that every GST practitioner should remember: the words are not to be mechanically recited in the notice. This is enormously significant because a notice saying the taxpayer suppressed facts is a conclusion. A legally meaningful notice must disclose which fact, what was the taxpayer required to disclose? How was it concealed? What evidence demonstrates deliberateness? How did that concealment result in tax short payment or excess ITC? That is the difference between a statutory allegation and a factually founded allegation. Now comes the most interesting part. Is Tata Steel decision creating a completely new doctrine? No, it is not. The better understanding is that Tata Steel decision is an evolution of established Supreme Court jurisprudence on extended limitation. And to understand Tata Steel properly, we need to go back before GST. The first important stop is in Cosmic Dye-Chemical versus Collector of Central Excise. Of 1994, the Honorable Supreme Court goes to extent that suppression of facts must be willful and deliberate. The case concerned the extended limitation provision under Section 11A of the Central Excise Act. The Supreme Court made an important distinction. Fraud and collusion inherently carry an element of intention, and in the case of misstatement or suppression, the statutory expression itself used the qualification willful. Therefore, a mere incorrect statement or omission could not automatically justify the extended period. The court connected the exceptional limitation with the intention to evade duty. That is the first building block. Then came Pushpam Pharmaceuticals Company versus Collector of Central Excise of 1995. This case gives us an even more powerful principle. The Supreme Court explained that suppression cannot simply mean every omission. The statutory context required a strict construction. The court held in substance that suppression involves a deliberate act. In taxation, the relevant idea was deliberate non-disclosure of correct information with the purpose of escaping duty. And the court added another powerful principle. Where facts are known to both sides, the omission by one party to do something which it might have done does not necessarily constitute suppression. That principle is extremely important in GST, because GST operates in an electronic environment. Returns are filed electronically, invoices move through systems. ITC information appears through system-generated statements. The department has audit powers. The department has access to returns, registrations, books, and transactional data. Therefore, the question, was this information actually concealed from the department, can become critical. The jurisprudence continued in Anand Nishikawa Company Limited versus Commissioner of Central Excise of 2005. The Supreme Court again examined the invocation of extended limitation under the Central Excise Law. The court ultimately held that the extended period was not available on the facts and restricted the demand to the normal limitation period. This is important because it reinforces the architecture of the doctrine. The normal limitation period is the rule. The extended period is the exception, and an exception cannot be invoked merely because the revenue wants additional time. There must be material satisfying the statutory conditions. This is the jurisprudential bridge from the old indirect tax regime to Tata Steel. Now put the cases together. In Cosmic Dye-Chemical, it was stated that willful conduct matters. In Pushpam Pharmaceuticals, it was formulated that suppression is not every omission, deliberate non-disclosure matters. In Anand Nishikawa, it was held that the exceptional period cannot be sustained without the necessary factual foundation. And then, current Tata Steel decision. Those foundational facts must actually appear in the Section 74 notice itself. That is why we would not describe Tata Steel as a sudden departure from earlier jurisprudence. It is better understood as the GST era articulation of an established judicial philosophy. The terminology has evolved, the tax statute has changed. The electronic GST ecosystem has changed, but the fundamental judicial question remains: has the revenue established the factual foundation necessary to invoke the exceptional limitation period? Now Tata Steel decision introduces another extremely important dimension. The case originated from an audit objection. But the Supreme Court emphasized that proceedings under Sections 73 and 74 can be initiated only upon the satisfaction of the proper officer issuing the SCN, and in a Section 74 case, that satisfaction must extend to the statutory ingredients. In other words, audit objection may trigger examination. But audit objection cannot replace the proper officer's statutory satisfaction. The distinction is subtle but powerful. An audit officer may say there is an ITC mismatch. That is one proposition. The proper officer must independently ask, is there actually a mismatch? And then, was it caused by fraud, willful misrepresentation, or suppression? And finally, what are the facts establishing that conclusion? That is application of mind and not pasting audit objection report in show cause notice. The facts become even more fascinating. The department had placed the proceedings in the call book, meaning the matter was kept in abeyance. The department was itself contesting the audit objection before the Public Accounts Committee, yet later, as limitation approached, a protective demand was proposed. The Supreme Court found this sequence significant. Why? Because the department's own conduct suggested that there was no settled satisfaction even about the underlying mismatch or short payment, much less about suppression. And the court rejected the concept of a protective assessment as a mechanism to preserve a GST demand merely because the statutory clock was running. This gives us another important proposition. Limitation pressure cannot manufacture statutory satisfaction. A notice does not become valid merely because limitation is about to expire. There is another important statutory point. The department relied upon Explanation 2 to Section 74. But the Supreme Court noted that this explanation had already been omitted with effect from 1 November 2024. Therefore, the department could not simply use the old statutory explanation as a shortcut to establish suppression. This is important in the post-2024 GST landscape. The law has itself moved. Section 74 now belongs to the earlier period architecture, while Section 74A governs the latest statutory regime. So practitioners must be extremely careful about the relevant financial year, the applicable statutory provision, the limitation period, and the statutory definition or explanation that actually existed during the relevant legal framework. You cannot construct a Section 74 case by mixing different versions of the statute. So what should a taxpayer or practitioner do when a Section 74 notice arrives? Do not begin by asking, is the tax demand correct? Begin with a different question. What exactly is the alleged suppression? Then ask 5 questions. Number 1, what specific fact was allegedly suppressed? Number 2, was the taxpayer actually under a legal obligation to disclose that fact? Number 3, what material demonstrates deliberate non-disclosure? Number 4, how did that alleged suppression cause the short payment or wrongful ITC? And number 5, are those foundational facts actually stated in the SCN, or has the department simply inserted the statutory words, fraud, willful misstatement, suppression? That 5th question is where Tata Steel can become particularly powerful. Now we can return to our central proposition, why call suppression a jurisdictional fact? Because Section 74's exceptional limitation is not available merely because the department says it is available, the statutory precondition must exist. And the proper officer must apply his mind to that precondition. Therefore, suppression performs a gatekeeping function. If the foundational facts necessary to establish that statutory condition are absent, the revenue cannot simply cross the Section 74 gateway by using the correct vocabulary. That is why suppression is not a drafting formula. It is a factual and legal conclusion which must have a foundation, and Tata Steel decision makes that foundation visible. There is, however, an important nuance. Tata Steel decision does not say that every Section 74 notice will fail. Nor does it say that the department can never establish suppression through circumstantial evidence. The Supreme Court's criticism was directed at the absence of foundational facts in the notice before it. Indeed, the court gave the department liberty to initiate an appropriate Section 74 proceeding if it thought fit, provided the foundational facts were brought out in the notice and the order was passed within the permitted period. So the correct proposition is not, Section 74 is dead. The correct proposition is, Section 74 or 74A cannot be sustained by assertion alone. That is a much more accurate reading. And there is one final procedural twist. The Supreme Court set aside the existing SCN and the consequential order. But it expressly permitted the department, if it thought fit, to initiate an appropriate proceeding under Section 74 with the necessary foundational facts. The court specified the outer date of 28 February 2027 for passing the order in such proceedings. Therefore, the judgment is not simply a taxpayer victory based on limitation. It is something more precise. It tells the revenue, you may proceed, but you must proceed according to the statute. That is a very important constitutional idea. The judgment protects the taxpayer from an improperly invoked exceptional power without disabling the legitimate exercise of that power. Now step back, why is this judgment important beyond Tata Steel? Because it reinforces a basic principle of tax administration. Exceptional powers require exceptional statutory conditions. The revenue cannot transform an ordinary tax disagreement into an extended limitation case merely through drafting. And the taxpayer's defense should therefore not always begin with, here is why our ITC is correct. Sometimes the first question should be, has the department crossed the statutory threshold necessary to invoke Section 74 at all? That is a jurisdictional question. And that is why the older cases matter. Cosmic Dye Chemical gave us the importance of willfulness and intent. Pushpam Pharmaceuticals taught us that suppression is not every omission. Anand Nishikawa reinforced the exceptional nature of extended limitation. And Tata Steel brings the principle into the GST framework by insisting that the foundational facts must appear in the SCN itself. So the next time you receive a Section 74 notice containing the words, fraud, willful misstatement, suppression of facts, do not be intimidated by the vocabulary. Read beyond the words. Ask, what is the fact, what was concealed? Why was it required to be disclosed? Where is the evidence of deliberate concealment? What is the causal connection with the tax shortfall, and where are these foundational facts stated in the SCN? Because after Tata Steel decision, the critical question is no longer merely, has the department used the word suppression? The real question is, has the department pleaded the facts necessary to make suppression legally sustainable? And that brings us back to the proposition with which we began. Suppression is a jurisdictional fact, not a drafting formula. This is not a new philosophy invented in 2026. It is the continuation of a line of Supreme Court jurisprudence. But Tata Steel has given that principle a particularly sharp GST formulation. And that is why this judgment deserves close attention from every taxpayer, tax administrator, and GST practitioner dealing with Section 74. If you found this analysis useful, subscribe, like, and share for more Supreme Court, High Court, and tribunal developments in GST and customs litigation. Because in tax litigation, sometimes the most important question is not how much tax is payable, it is, did the department have the statutory power to travel this far in the first place? Thank you for watching, and comment if you require video on any other topic.